It's Breakfast with Friends, and such an honor to be joined now on the platform of StreamYard with Michael Swain from Freedom of Religion South Africa. Michael, good morning, sir, and thank you for your time.
Good morning, Jonathan, and good morning to Breakfast with Friends. Always good to be with you.
Always good to be with you too. So, Michael, the Constitutional Court recently gave a landmark judgment on the definition of hate speech. Tell us about the case. This was just in July. What is the matter all about in the Kaalani case?
Well, that's an interesting case, particularly because it's actually been going on for 13 years. And your listeners may or may not know that John Kaalani was a very well-known journalist, radio presenter, and he wrote an article in the Sun newspaper in Johannesburg entitled "Call Me Names, but Gay is Not Okay." And in that article, he accused homosexual people of being the cause of erosion of societal values. He argued that they should no longer be allowed to marry legally. He endorsed the most reprehensible remarks from former Zimbabwean President Robert Mugabe. And he also basically almost made homosexuality akin to bestiality. There was a cartoon of a man marrying a goat in that paper. And of course, understandably, the Human Rights Commission were inundated with complaints. So they took out an action against him under PAPUDA. You may recall we've been speaking about PAPUDA as well. That is the Promotion of Equality and Prevention of Unfair Discrimination Act, under Section 10.1 specifically. And he lost in the first instance, particularly because the definition of hate speech in PAPUDA was very broad. And that was what he was arguing, that the fact that the word hurtful was included in the definition meant that it was broader than the definition for hate speech in the Constitution. Now, just briefly on hate speech, of course, the broader we define hate speech, the less free speech we have. So the constitutional definition of hate speech was essentially, it's an advocacy to hatred with an incitement to do harm. And harm is often physical harm. And so, like, kill the farmer, kill the Boer, classic hate speech. Who do we want you to hate? Farmers. What do we want you to do with them? Kill them. And so he was arguing, therefore, that although, yes, what he said wasn't good, and it certainly wasn't, then at the very least, it was within the Constitution's definition of hate speech, because harmful was too broad. And the Supreme Court of Appeal, when he appealed his original decision, agreed with him, and then it went to the Constitutional Court, which literally, after 13 years, has finally given the definition of hate speech, which is very important because, of course, hate speech is speech which is not protected by our Constitution.
So how has the Constitutional Court now defined hate speech?
Well, the one thing they did, which was, we think, a very good thing, is that they said that the word hurtful, which was in PAPUDA, was actually, as they call it, irredeemably vague. And if you think about it, it is exactly that. I mean, hurtful, what does that mean exactly? It is so subjective. And of course, given that there can be significant sanctions for hate speech, to have it defined in a way which you actually don't really know who's going to be offended or by what you said or not, is very difficult. So what they did was they made it much more objective. And they said that it's basically speech which somebody says or writes or does something which a reasonable person would understand to have a clear intention to be harmful or to cause harm and to promote or propagate hatred. So this is a very important definition, therefore. And of course, it also includes prohibited grounds. So the actual definition reads, words that are based upon one or more of the prohibited grounds. Those would include things like sex and race and including, of course, sexual orientation against any person that could reasonably be construed to demonstrate a clear intention to be harmful or to incite harm and to propagate or promote hatred. So the definition is now, thankfully, relatively narrow. And that's a good thing. Because obviously, as I say, the broader the definition of hate speech, the less speech or the less you can say without risk of sanction. And of course, we also now have definitions for both hate and harm. So the idea, and I think the outcome, is that there is now at least an objective standard, and it is a more narrow definition than was included in the original PAPUDA.
Makes a lot of sense. But what are the types of factors which will help to define whether or whether not words or statements will amount to hate speech?
Well, the interesting thing in the Kaalani case, of course, was that they looked pretty closely at not just what he said, but where, the context of what he said. So, Kaalani himself, the identity and the status of the speaker, he was a seasoned journalist, a commentator. He was a veteran of the liberation struggle, and he wrote, very well read and, if you like, well followed articles, which his viewers took seriously, or his readers took seriously. And of course, the context, he also used as his backdrop the vile remarks that Robert Mugabe used to make about LGBT people. And also the impact of the speech is important. The speech was basically, as the court put it, sort of an unadulterated vilification and debasement of the LGBT community. It went way beyond just criticism, and its impact was therefore much broader. And then the question was, well, what is the likelihood of inflicting harm or propagating hatred? And the court said about this case, it's difficult to conceive a more egregious assault on the dignity of LGBT persons. So that is, again, the context. But what it specifically did say, which is interesting, is that hate speech excludes private communication or communication between individuals. So the result of the whole case was essentially that the Kaalani, who obviously then lost the case, that article, what he said in the article, plainly constitutes detestation and vilification of homosexuals, and that's what amounts to hate speech. So again, it's something which is obviously pretty extreme. It's not just some sort of casual remark or what have you, or even perhaps a reasoned critique, particularly if we're speaking about religious freedom issues.
Now, on that note, let's talk about it. So the implications, what are the major implications for religious freedom as a result of the new definition of hate speech?
Well, obviously, it's very important because, these remarks would include remarks whether made from the pulpit or social media or anywhere else for that matter. And it doesn't, of course, importantly, make it illegal per se to disagree with or approve of, for example, in this instance, because the case was about this, homosexuality. So therefore, to teach or preach or to otherwise share some moral convictions or religious texts on the issue would be acceptable. And the Constitutional Court has, in fact, already made that clear in previous cases. But whether or not it is something which amounts to hate speech, each case is going to be decided upon its own merits effectively. But it's probably important to note the context of the Kaalani case, because that does give an indication. So, for example, if you accuse the LGBT community of the rapid decay of societal values, or you insinuate that their choices are against natural order or amount to bestiality, or, for example, you say that they should be denied a right to marry and therefore effectively say that what they have as a right is actually should be at least unconstitutional and not worthy of the protection of law. That type of thing is going to get you, I think, into hot water pretty quickly, because that will fall very easily within the kind of parameters of the Kaalani case. So probably wisdom would say, without a doubt, that it is important. And I think, honestly, I think Christians should do this in any event, that LGBT people, they are human beings. They're worthy of equal human dignity. And we need to say that. And I think it's also important to note that in our Constitution, and even if some people don't like that fact, sexual orientation is a protected category. So they have legal protection. But having basically sort of, shared that parameter and drawing a distinction perhaps between the secular or legal position, it is still perfectly acceptable to define perhaps what your faith belief might say is the religious or the faith position of the LGBT rights or issues or practice or whatever it may be. The amount of hate speech, or hate speech rather, does not amount to offending people. Even shocking people, they said, was okay. So, but it is important, I think, to balance, obviously, what you may say, to make sure that human dignity and their, obviously, legal rights are protected and respected.
So important. As we quickly wrap it up, Michael, we're running out of time, but in terms of this new judgment, or this judgment, not a new judgment, but this judgment, what are the next things that we are likely to see as a result of the judgment?
Well, the one thing, of course, is the Papuda Amendment Bill is going to go into a next draft. You might recall we had 150,000 submissions that were made basically to say that what it did say was unacceptable. They're going to bring a new draft, so it's certainly going to be in that. And then, of course, yesterday there was a briefing by the Department of Justice of the Parliamentary Portfolio Committee for Justice on the hate speech bill. That, you remember, about 3 years ago now, was very topical, and that will criminalize hate speech. So again, very significant. This also, by the way, is in keeping with South Africa's accord with the United Nations Rabat Plan of Action, which says that criminal sanctions related to unlawful forms of expression, again, it does say should be seen as a last resort measure to be applied only in strictly justifiable situations. But it does say that there should be, in law, according to our agreements with the UN, a criminalization of hate speech. So these are significant things. Watch this space, because when that bill comes out, and it will come out very shortly for comment, it is so important that we look at it, we understand it, and that we make our voices heard.
Most certainly. Michael Swain, thank you for your time. And for those who perhaps just came in at the tail end, you can watch it on our Facebook page or on our YouTube channel. And for more information, obviously, you can go to their website, forsa.org.za. That's forsa.org.za. Michael Swain, thank you and have a wonderful day.
Thank you, Jonathan. Bye-bye.